good afternoon. Thank you all for being here. I'm Catherine Brokaw, the Dean of Students for Emory Law School. Very happy to participate in this afternoon panel. We are going to be talking about actions that can be taken as remedies for discrimination. And we have with us a very distinguished panel. I won't list them in order. I'll just list them in what I've got on my list, and they can stick a hand up so that you can make sure you know who they are. We have with us Barry Allen Roberts, who was the lead plaintiff in the landmark case of Roberts v. Texaco, Inc. We have Jeffrey Bramlett with Bondurant, Mixon and Elmore. We have Michael Allen from the law firm of Relman, Dan and Colfax, and Brian Spears from the National Police Accountability Project. And what we will do, I think, is starting with Ms. Roberts, we will have each panelist say just a few things for a couple of minutes each about their perception of the overall question of what is the current status of core civil rights laws and who are the actors who have a role to play in enhancing enforcement of those laws. And then we will start a lively discussion with this very verbal panel, and I hope that the audience will join in eventually with some questions. So, Ms. Roberts, let's start with you, please.
Hi. I am not an attorney, let me say that, and if the orange jacket doesn't make it obvious, I'll say that again, I'm not an attorney. But I was the lead plaintiff in the Roberts versus Texaco case. And I believe that while the law needs theory, development, discussion, debate, it also needs practical application. And today's discussion has been very heavy on the theory and the development. I represent a successful application of the law. I represent a person who was affected by the law. I was affected by the law being broken at Texaco. I was affected by the law being adhered to once the case was settled. I was the woman that was paid less than the men that worked with me. Because of my gender, I was paid less. I was the 40-year-old who was too old for a promotion because of my age, and I was the African-American that was discriminated against because of color of my skin. In this talk today of post-racial America, I have a lot of questions.
All right. I am a lawyer, and I'm proud to be a lawyer, but I will tell you this, what motivates me to do civil rights enforcement work are people like Barry Allen Roberts, who have the courage to stand up in a workplace and speak the truth to power. As lawyers, you know, I hope we have some skills in terms of coming to practical resolutions of problems of this sort. But it is the inspiration of people like Barry Allen who really, along with her counsel, Cyrus Mary, in that case, put forth a model for how large corporations can improve the quality of their treatment of the people who make them the money and keep the shareholders happy. We were able to take the template from the Texaco case in a case that Barry Allen's counsel, Cyrus Mary, and I worked on together against the Coca-Cola company about 10 years ago. And I think we took the Texaco template and put it on steroids. And I'm very proud of some of the ways in which we have improved that global company's treatment of its people and its management of its human capital. So we'll maybe talk about that a little later as well.
Thank you, Jeff. Again, my name is Brian Spears. I'm an attorney in Atlanta, and my specialty is in the area of enforcing constitutional rights in the law enforcement setting. That has been a area that I've worked in for quite some time, and in being invited to come for the program today, I had the opportunity to step back and think a little bit about what it had been like at the outset of my career to bring Section 1983 cases involving police misconduct and the like, and what it's like today. So to speak to the question of what's the current status of civil rights laws, what I would suggest is that in the area of enforcing constitutional rights in the law enforcement setting, or generally speaking, trying to use Section 1983 in the setting of bringing claims against governmental entities, that it is frankly quite remarkable how stunning the rollback has been to the access to courts for constitutional rights claims in the last 30 years. I put it 30 because I started practicing in 1975. I started practicing in Georgia in 1978 and brought my first police misconduct case in 1980 and have been working at it since that time. And frankly, if I were to look at the pleading that we filed for that first case that I brought, I'm confident that we would have been tossed out on our ear if we brought it today. Not that there weren't civil rights violations, but that the scope of the allegations, the scope of the defendants who we sought to hold accountable today would not stand. Particularly important in the area of law that I practice is this defense of qualified immunity. And what it of course stands for is the proposition that the courts have fashioned this. It's not statutory, of course. It stands for the proposition that although your constitutional rights have been violated, and although a court could conclude that that was the case by virtue of what the governmental actor had done, so long as the governmental actor can claim that they nonetheless acted reasonably, then you lose. And you lose either at the motion to dismiss stage or more commonly at the motion for summary judgment stage. It has become very, very difficult to overcome the qualified immunity defense in the context of bringing these kind of cases. It's not impossible, though, and not only that, I think that if plaintiffs' attorneys are careful and do as much homework as they can in advance of bringing suits, that they are still winnable. But it is a daunting task, and I think I want to pass it over to you now, and we can have more discussion about this area.
I'm Michael Allen, and for the last 25 years I've been a jack of all trades. 25 years out of law school, first 10 spent in a legal services setting, and then 11 years after that at the Bazelon Center for Mental Health Law, which is a national civil rights organization focused on disability issues, in the last 4.5 or so at Relman, Dane & Colfax, which is a 15-lawyer civil rights plaintiff side firm based in Washington, D.C., but with a national practice. And I say jack of all trades purposely because I've sat through the conference today and I've listened to scholars speak and I've listened to judges speak, and these people are way smarter than me. I've done community organizing in my day. I've done litigating. I've done policy work with federal and state agencies. I've done writing and teaching. I haven't gotten really good at any of it. What I've been good at is having cases drop in my lap. And our practice is principally focused on the Fair Housing Act, where standing is very broad, right to the constitutional limits, and where the case law is very good. I do some work under Title VI and the ADA, and for the most part, we have not run into a slew of the courthouse doors being closed to our clients. We've litigated a bunch of big cases against big players like Wells Fargo Bank in Westchester County, New York. So far, we're keeping our heads above water. I don't mean that just in a financial sense, but I mean that the litigation that we're doing continues to press ahead in, I hope, some creative ways. The Westchester case involved one of these creative ways, which was the use of the False Claims Act to try to enforce civil rights certifications for recipients of federal funds. And so to answer the second question that Dean Brokaw gave us, I think that who has a role in the enforcement of these core civil rights laws? If I can just tick through the various kinds of things I've done in 25 years out of law school, I'd say principally grassroots groups have an important role in making sure that these civil rights protections actually live in the community setting. We need way more eyes and ears than we have now available to us. There's a role for the federal government. I can talk later about how I think our Westchester litigation woke up the Department of Housing and Urban Development to enforcement of its own obligations on its recipients. The private bar, we'll talk about that, obviously an important player. Civil rights and fair housing groups at the community level have an important role in connecting, and legal services organizations an important role in connecting. And I guess I'd say finally, through the vehicle of the False Claims Act, every taxpayer in the country has standing to challenge lies that are transmitted and false claims that are made to the federal government. I think we all have a role in enforcing these civil rights obligations, and happy to join the discussion.
Okay. The way we're going to do this is I will encourage our panelists to respond to others' anecdotes, assertions, whether or not they agree with each other. Hopefully no blood will be shed. As I told them on our conference call, I'm not looking for crossfire here. But after we've had some ongoing discussion, we will open it up so that you too can join in that conversation. So one of the questions that I would like you all to discuss a little bit is our earlier panel with the judges talked quite eloquently about the past importance of the press and journalists in exposing injustice to the rest of the world, and even putting it more vividly in the faces of people who kind of sort of knew about it but had been willing and able to turn away from it, and that role is greatly diminished. On the other hand, it seems to me that there may be a role for non-traditional media, which effectively allow members of the lay public, non-journalists, to perform that visibility role. And I wonder if you all have any thoughts on that. Has that been something that you've seen in your practice area? Ms. Roberts, is that something that you think might have changed or affected your experience? And so maybe Ms. Roberts can start with that one.
I'm so glad she asked this question. For those of you who don't know, when our case was settled, the Texaco case was settled in 1996, November 1996. Actually, I think this week might even be the anniversary. The claims, the noise, the rhetoric was all about the amount of the settlement. It was $176 million, covering 1,400 African Americans. It was unheard of. There was clamor from the civil rights groups. Jesse Jackson came. This also took place in White Plains, New York. Jesse Jackson came. There was outcry everywhere, in the newspapers, television. I just remember being inundated. But the story was always about the money. All the questions were, Ms. Roberts, $176 million. Ms. Roberts, Texaco stock dropped. Ms. Roberts, what do you think about this amount of money? Nobody asked about the discrimination. Nobody asked about the lawsuit. Nobody asked me how it felt to go to work every day for 3 years in the middle of a lawsuit. Nobody cared to talk about why we even brought the suit. They wanted to talk about the money, interview after interview. So in order to get that story out about the suit and about our claims and about what we were really fighting for, I decided to be my own advocate and write my own book, and not wait for CNN or not try to turn the questions to what I wanted to talk about on Dateline or Nightline. So the press, I think, has become, they get caught up, and I don't know if it's time, I don't know if it's concern, I don't know if it's consumer, but they don't want to tell the real stories. They don't want to ask the hard questions. They don't want to print what they think is boring, They want to print what they think will sell.
So Jeff, what do you think about that? What has your experience been?
Well, I think the availability of a press that covers stories like the Texaco litigation, like the Coca-Cola employment litigation, is critical to helping the public understand the realities of how discrimination and remedies against discrimination have evolved over time. You know, back when you think about the laws prohibiting employment discrimination, they were quite remarkable in this sense. When Congress passed these laws saying that women should get equal pay for equal work, that you could not discriminate on the basis of gender, that was not the reality in the American workplace. I mean, women were clearly discriminated against in terms of pay and promotional opportunities. And so after about 10 or 20 years, you still had these gross cases where employers were paying a different wage scale to African American employees versus white employees. The nature of discrimination in the workplace has become more subtle in some ways, and part of that is because, as Brian observed, courts have drifted away from the proposition that discrimination can be proved by impact as opposed to evidence of purposeful discrimination. And so without a vibrant press to inform the public about these issues, and I agree with Barry Allen that often individual journalists ask the wrong questions, but the larger issue is making sure that the public understands both what the problem is and how the solution advances everyone's interest, the employer as well as the employees, in terms of improving the quality of practice of managing people. Without a press to do that, it's going to be hard to continue to do it the way we've done it in the past, but we can talk about maybe some other ways to get that information out.
And Brian, since you work so much with police brutality and accountability cases, I wonder if you have some thoughts on the advent of digital information and how that may have changed how some of those cases get proven, how it comes to attention, what can be done with the fact that the citizens in some ways have become the press.
Well, let me talk about it in two aspects. One is simply the ways in which law enforcement has changed how it does its business in a way that does make it more possible, I think, to get to the bottom of a story and really understand what happened. I'm working on a case now that involves a young man who committed suicide in a jail, and the capacity to actually see. The man was in isolation because he was a suicide risk, and guess what? He committed suicide. But they actually have enough electronic means, both digital recording of the calls as well as the recording of the conduct of officers in the jail, that when the officers who were on duty attempted in the immediate wake of the suicide to cover up the fact that they had lied on records of having checked up on this fellow. That came out because of the improved digital and video capacity of law enforcement. But back to the other aspect that you asked, having to do with the public as press sort of idea. On the one hand, I think that there is a greater capacity for the public to play an important role in recording events and using one's handheld cameras and things of that type. But I do want to say that it's disturbing to me how quick the pushback has come from law enforcement, supported by prosecutors and by existing law. And by pushback, I mean there are a wide range of instances where, for the act of having recorded both audio and visual of conduct by law enforcement officers against one or another citizen, that the act of recording has been deemed to be a violation of privacy laws on a state law basis, such that persons who have tried to serve that role as a sort of public eye to a public event have found themselves being prosecuted for violations of what historically we would have called the wiretap laws because they're recording audibly matters without the permission of both parties. And I think that there needs to be a change in the law, for one thing, to take into account what I consider to be the public's right to record the public conduct of those who are public officials. And it's the jury is still out, if you'll forgive my use of that expression, on whether or not that's going to be uniformly applied. It's really dramatic. I've been really surprised at just how much back and forth is going on right now on that kind of an issue.
And Ms. Roberts mentioned the drop in Texaco's stock price as a result of the settlement, and I'm sure it had been affected throughout various phases of the litigation. Obviously, stock price doesn't relate as much to police cases. Michael, I wonder if you and Jeff have any thoughts on the impact of shareholder value, if you will, on this kind of litigation, and how does it affect these kinds of claims?
I'm happy to cede my entire time to Jeff on that particular point, because most of my targets are not publicly held corporations.
Yeah. Well, if you walk around this campus, you'll note names like Woodruff and Goizueta, and so we'll talk about Coca-Cola for just a minute, but in a respectful way. I do think that the reaction of the investing public and let's face it, we're not talking about small fry who are investing their college savings or retirement savings. We're talking about institutional investors. They can have a massive role in terms of influencing the conduct of large employers if they're inclined to do it. There's been, in my view, a real breakdown between the ideals of corporate governance and the notion that directors of corporations are there to look after the shareholders, and what happens in real life, which is the CEO tends to invite on a board those people who are much like him, and there is a lack of too often a lack of diversity of within corporate boards, and they don't stand up for the shareholders. So I think, that's obviously, we're talking about, on the federal level right now, financial reforms and so forth. I think one of the most important ones is to really get back to the notion of corporate governance in which the board of directors functions as an independent source of advice and counsel to the management of companies that says, you really do need to do right by employees because you can't do the company's business and make the company's profit without them. So if you treat them fairly and the board advocates for that, you really can improve the quality of the performance of these corporate employers in a way which is a win-win for the employees and for the employer.
I'd like to comment further on that. I think the importance of the shareholders and the importance of the stakeholders, at least in our cases dealing with Texaco. Texaco was, after the tapes came out, after all the information came out as to what their executives were saying about us and destroying evidence, Texaco was still resistant in settling the suit. It wasn't until the shareholders and the stakeholders came forth and started talking about selling off Texaco stock, taking a stance almost like apartheid, like when companies pulled out of South Africa. It wasn't until that happened, and it happened to the tune of $1 billion in one day, and $1 billion the next day, that Texaco came to the table. And I can't say enough, not just about the shareholders, the CalPERS or the large employment retirement funds, but there were also stakeholders. There were also people threatening to go back to the 60s with boycotts, or someone called it, selective shopping, those kinds of things. So I think that is important as well.
And Barry Ellen, if I'm not mistaken, in Texaco, part of the remedy involved creating a task force that essentially advised the company about improving the quality of its human resources governance practices and its employment practices generally. Could you talk about that particular aspect of the remedy?
Sure. part of the remedy that I think our attorneys came up with, which was so innovative and which really proved to the public, I don't know about Texaco, but it proved to the public that we weren't just about the money. The case was never about the money. We had never, in any form or fashion, thought about suing Texaco for $176 million. That was not our case. Our case was about equality in the workplace. Our case was about equality in pay, equality in promotion, equality in access. Our case was an equality case. And as part of the settlement, even after the money was discussed, our attorneys came up with a way to help Texaco. Instead of Texaco, I mean, the case could have been settled for money years before, but they had what they called a scorched earth policy. They weren't going to try to change the company. They didn't want change. They wanted things to stay the same, and they kept saying that. They wanted things to stay the same, so they were going to destroy us, the plaintiffs. That was their mission. But with the Equality Task Force, that brought in outsiders from a wide spectrum of business, of civil rights, of corporations, of public policy. It brought in a wide spectrum of people to go in and change the company. And one of the things that the company was lacking, one of the things that many companies are lacking, even if they want to change, is they don't know how. There was no map for them. There was no way to tell them how. There were no measurables. There were no accountability standards. There were none of those kinds of things that even if a company said, you know, I have a problem here and I want to fix it, that they wouldn't know how. But when our attorneys came up with the Equality Task Force, and that task force was able to work with Texaco and work with its shareholders and work with its stakeholders and work with its employees and work with the community, they were able to put together a map and a resource that, as this gentleman said, Coca-Cola used and used it on steroids. And other companies used it without having to be sued, without having to have litigation and those kinds of things.
So I'm not going to let Michael off the hook. What I'd like to hear from you is, who are the entities in this current legal environment who can have a meaningful impact on the kind of litigation that you are doing? And how has that changed over your years of action?
Well, and I think still changing, by the way, you know, that there's that old saying about how we're building the bicycle while we're learning to ride it. And I think that, you know, whether it's increasingly difficult to get claims into court, or whether it's simply that discrimination is more nuanced than it used to be, we're still trying to figure these things out. But I guess what I'd say is this, that picking up on what Barry Allen just said, our Westchester case was principally an equality case. The question was, could Westchester get $10 million a year in federal money while claiming to the federal government that it was dealing with issues of segregation, and that it was dealing with its affirmative mandate to knock down segregative barriers. And the problem, you know, with segregation is it really puts a target on the back of communities. It makes it all that much easier to go in and do predatory lending or steering people away from or to particular communities in terms of residential real estate ownership or tenancy. But I guess picking up on that point about the equality principle, I guess I'd say we learned something in this Westchester litigation, which is that there are lots of individual claims that can be brought when people face discrimination and segregation, but there are also some clever ways in which folks can use non-traditional approaches to this. As I said, the Fair Housing Act grants very broad standing, so civil rights and fair housing groups that are involved in trying to stem segregation on a more global basis have standing to sue under the Fair Housing Act. And so we've seen a really broad expansion of the kinds of plaintiffs bringing fair housing claims, not only individuals and not only civil rights groups, but also we've seen the National Association of Home Builders bringing claims under the Fair Housing Act when localities have restrictive zoning and land use laws that keep them from building affordable housing. We have obviously citizens standing up and claiming discrimination as well. We have a number of cities, a couple of whom are our clients, the The City of Baltimore and the City of Memphis, Tennessee, are our plaintiffs against Wells Fargo for the effects of predatory lending that Wells Fargo has done in those particular communities. So I guess our view is we like to take and win cool cases, but we also like to see how we can really spread out the responsibility for enforcing and bringing, bringing to justice under these civil rights laws. And to the extent that we've been fortunate under the Fair Housing Act to have very, very broad standing, we've been able to spread those out. One last word, if I could, about Westchester. Lots of civil rights claims were considered on the way to filing this Westchester case, but my client, Craig Gurian at the Anti-Discrimination Center, sort of lit on this false claims idea, which is to the extent that Westchester County, like the defense contractor that's trying to sell to the United States military, makes false claims about what's being done as a condition of getting federal money. If those obligations aren't fulfilled, if there are in fact lies to the federal government, there's this wonderful treble damages provision in the False Claims Act that really starts to get at, maybe not in the same way that it would for shareholders, but in terms of towns and cities and counties and states around the country, a real price for discrimination, that if we can harness this new mechanism to enforce civil rights laws with a treble damages provision and a private party getting a share of the recovery, that is a real incentive to be eyes and ears in the community, pretty soon, as I said, we could have almost any taxpayer standing up and trying to enforce these laws and having a vehicle for doing it.
Barry Ellen, I'd like to hear a little bit more. You mentioned that the journalists mostly didn't ask what it was like for you to be a plaintiff, lead plaintiff in this massive lawsuit, and you're still going to work every day for 3 years. And I wonder if you can communicate to our audience a little bit about what that was like, because that seems to me such a significant hurdle to litigation that relies on individual plaintiffs. You've got to have individuals who are willing to undergo that experience.
I think that was certainly a big challenge. The fact that when the suit started out, there were just two of us, and we were both in Westchester. We were both at the corporate headquarters. And over the year, or over the next 2 years, we were able to get other plaintiffs in other areas of the United States who worked for Texaco. That was also to show that it was systemic. It wasn't just, Syl and I, his name was Syl Chambers, in the corporate office in New York. But the whole idea of going to work every day, it had its strengths and it had its weaknesses. The strengths were, many times people would say, how can you come to work every day? And my thought was, how could I sue Texaco working for AT&T? That it didn't make sense, that the information that I needed was there, that the people who I wanted to show how wrong they were there, that it would have been almost like, throwing a stone at somebody's window and running away. It had its challenges on the one hand, because I did think that I would be supported by the other African Americans who worked at Texaco, and it had the opposite effect. I became a pariah. And so the other African Americans, even though I thought, or I felt very strongly that I was standing up for them, and they had no idea of the depth of the discrimination that they were undergoing. That was all part of the game that Texaco was playing. I had been at Texaco 5 years, a little less than 5 years. Prior to working at Texaco, I was a vice president at the Chase Manhattan Bank down in Manhattan. And I don't want to go into a lot of the story about how I got to Texaco, but Texaco was my client when I worked at Chase, and they recruited me to come work for them. But having the other African Americans at Texaco turn their back on me, not talk to me, not wanting to be seen with me, and then having the gentleman, I use that word loosely, having the men at Texaco who I was actually suing and naming in the suit, walk past my desk. And I remember after the suit started, they started a diversity council at Texaco that was all white men to show that they had a diversity council. And so I went and I asked this guy, I said, Steve, there seems to be an issue here. There are no women, there are no people of color, there's nobody else on this diversity council but you guys. And he turned and he said to me, he said, well, Barry Ellen, I'm the resident liberal. I can represent your views. Going to work every day was critical for me. Syl was very strong as well. We were both determined not to leave Texaco until this thing was settled. But it was hard. There were times when there were threats, overt, not just subtle. There were times when there were people who were just angry. And someone came up to me and said, how dare you sue this company? You're an affirmative action baby and you ought to just be glad to be here. So, I mean, those kinds of things. And it took a certain strength, and it took a certain, as my mother would call it, hard-headedness on my part, just to be there. But for me as a plaintiff, I can't speak for anybody else, but for me, there was no other place for me to be.
So for the rest of our panel, each one of you represents plaintiffs in different kinds of civil rights litigation. How do you as lawyers in your particular arena deal with the needs and the vulnerabilities of the individual plaintiffs, whether it's police brutality, whether it's segregation in Westchester, whether it's another employment discrimination situation? There are individuals involved who are taking some level of personal risk to be part of that litigation. How do you as lawyers support those individuals?
If I may, let me start here by saying that some of the most effective tools in civil rights enforcement arise from the ability to mount and get certified a class. And my observation from 30 years of both prosecuting class actions and defending class actions is there is, in many contexts, a great attenuation between the plaintiffs, the class representative or the named plaintiffs on the one hand, and the objectives of the class. And I find that the quality of lawyering diminishes the more attenuation there is. If you look, for example, at a typical securities fraud class action lawsuit, it's a lawyer-driven kind of mechanism. The lawyers are making decisions for the class. What we found and what I learned from the Coca-Cola case and from Barry Ellen's prior experience with Texaco is that lawyers can do a much better job of effectively representing the class if they have the benefit of astute, practical, involved people like yourself who are directing the lawyers as, because lawyers are agents. I mean, the principals are the clients. It's the client's case. In Coke, we were fortunate to have 3 of our 4 class representatives were graduates of MBA programs at some of the finest schools in the United States, and they were very astute business people, and they were very focused not just on a remedy for their individual experience, but for changing the way the company did business. And I think to the extent that we succeeded in that case in getting a remedy that really did affect people's lives at that company for the better, we did it because we had class representatives who were directing us, supervising us as lawyers, as opposed to that attenuation that occurs where you've got a class action that's really lawyer-driven.
Michael? Brian?
I'll just focus on a couple of our individual client plaintiffs to respond to your point. We don't typically have very large cases. I mean, we do have one class now of African American Secret Service agents who've not been promoted and retained and hired in the way that they should have been. That case has gone on, I think, now for 11 years against the federal government, apparently not making much difference which administration is in power. But I have to say that with them and with the plaintiffs that we represented, the individual 58 families that we represented in our Zanesville litigation, which was the city and the county withholding public water service for 48 years from an African American community, even as it served every other white community in the vicinity, that these folks have really become sort of members of our family. I mean, we're 15 lawyers and a total of 26 or 27 staff total. And when we have our dinner in December, our plaintiffs come and commune with us. When we're preparing for trial, we spend lots of time with them. They have our cell phone numbers. We're there to console them when the times get very difficult. We had a case against the Metropolitan Police Department in D.C. over a couple of years that culminated in a 2-week trial this summer, and literally we spent 24 hours with them, answering every question that they had as they were having to get up on the stand and testify against their, supervising officers and higher-ups. And I have to say that it just sort of comes out of the gut more than anything else. We're kind of at the street level, not entirely, but we practice as if we were, and otherwise I think we wouldn't be serving our clients.
Let me just pick up on one of the themes that you mentioned. In most of my cases are individual claims cases in the sense that I don't bring class actions in the way that others here may. And by way of an anecdote, I stopped bringing class actions involving prisons and jails after the Prison Litigation Reform Act became law, and that drew to an end my that part of my practice. But that said, what I try to do is approach the attorney-client relationship with the proposition that it's a partnership, and I call it that. I describe to my client that that's how I see it. I want to be a partner with them. They need to be a partner with me. What affects them in almost any aspect of their life could conceivably affect the suit, could affect myself. So I try to learn the person, if you will, of who the client is, and that's particularly, it's critically important if your client is. I handle wrongful death cases as well, and so of course in that instance the person harmed has passed away, and then you're dealing with their family. But particularly when you have a person who is, at liberty and around, and they have the fear of local law enforcement, sanctions for having brought a lawsuit, it's really important to make them a part of your conscious your conscious life, not literally like family, but you need to take that relationship very seriously.
Now, we have had some conversation about the class action lawsuit, and of course there have been quite a few changes in the handling and the procedures of class action litigation in recent years, and I wonder if our class action lawyers would comment on that, and how has that changed? Is it change that has made it more desirable or more effective for you all to look into sort of out-of-the-box type remedies and strategies?
Well, the case that we brought against the Coca-Cola Company in 2000 or 1998, 99, whenever we filed it, could not be brought in the circuit today. I mean, echoing what Judge Clemens said, the law in the circuit has become so hostile to the notion of impact evidence as a basis for establishing liability in an employment case that in this circuit there's simply no place to go with that. Other circuits have different law, and perhaps the Supreme Court will harmonize that in a way which would permit employment class actions to survive, but there's not a lot of traffic right now. And I guess I would say this, I mean, class actions are very rough justice, too. Barry Ellen, I suspect you have some stories to tell about the comments you got from other class members after you had stood up and played a leadership role while they sat back and didn't, and then they come to tell you about the portions of the settlement they deem inadequate. And that's just a reality of class, of any sort of solution that tries to deal with the legal needs of 1,400 people, I think your class was. Bounce off that.
I think, okay, again, I'm not a lawyer, but I think the idea, and someone said it earlier, Brown versus the Board of Education was class action suit. And if you're going to get something done in a substantial way and impact more than just yourself, and you're going to do it through the law, then it has to be done through a class action suit. I remember when I knew that I was being discriminated against. I didn't know how to verbalize it legally, but I knew that I was. I knew that I wasn't being paid what I was worth. I knew that the people that I was training were getting promotions, but I wasn't. I knew it. I didn't know where to go. There was no attorney on television saying, there were no ambulance chasers for employment discrimination suits. So I didn't know where to go. I didn't even know the questions to ask or the questions that would be asked me. But I knew that what I was experiencing in Texaco was bigger than Barry Ellen. I talked to two big attorneys in New York who said, we'll take your case. But the other people in the room, and I had taken 3 or 4 other people with me who thought that this was what they wanted to do. But the other 3 people in the room, we won't touch. We'll take you. I knew that I couldn't just sit there and say, okay, take me, because Texaco would take me, pay me off, and still continue the way that they were continuing. So whatever people who feel that a class action is the way to go, however they need to organize, however we need to vote, whomever we need to speak to make sure that this doesn't go away as a remedy, to make sure that class action suits, especially in discrimination cases, are wiped off the face of the earth. We need to do that. Maybe I'm sitting here saying we need to do that, and maybe that we is me. I don't know. But I do know that, and I feel very strongly, that if something is going to be done, it has to be done in a big way, that we don't live in a post-racial society. I don't know where that's coming from. I am a child of segregation. I started elementary school in a segregated school. By the time I went to high school, it was integration. Then I went through tolerance. I don't know if anybody remembers that, where we were teaching tolerance. And then I went through diversity. And now to find myself at 58 years old with my granddaughter back in a segregated school, I don't see post-racial. I see that there's work to be done. I see that there's work to be done through the courts. I see that there's work to be done through lawyers. I see that there's work to be done through grassroots. I see that there is work to be done. There have been improvements, major improvements. My mother never could have dreamt of being a vice president at Chase Manhattan Bank. But I don't want my daughter to think that that's all that she can be as a vice president at the Chase Manhattan Bank. And I don't want my granddaughter going back to a segregated school not dreaming that she could not be that.
So, Michael, recognizing that the class action lawsuit does still have a huge role to play and a lot of importance, even if some of its reach has been somewhat limited, you've raised strategies that involve things like the False Claims Act. What other avenues do you see as being out there? Are there avenues through government procurement, for example?
Was there an election last week? I haven't fully processed that yet, but let me make the following comment. This administration is more awake to the power of the federal purse than any administration that's been in office in the 25 years I've been lawyering. So I limit myself in that way. So since 1985. There is an interesting moment in time here where at the Department of Housing and Urban Development, we have some real civil rights muscle being exercised, not across the board, not as vigorously as we'd like, but in significant ways. HUD held $1.7 billion from the state of Texas in hurricane recovery money because it was not programming that money in a way that was aware of civil rights concerns. 6 or 7 months of negotiation, we settled that case, and now the money is provisionally released, but with a whole bunch of strings attached to it. In the Bay Area, the Bay Area Rapid Transit proposed to use $70 million of Federal Transit Administration money to build a rail link from the Oakland BART station over to the airport. This decision would have strangled off the bus service that serves the low-income black and brown people who live and work along that corridor. The FTA took a complaint from public advocates in California under Title VI saying, you have to do an equity analysis before you deploy the money in this way, and you have to ensure that it doesn't have these effects, apart from whether it was intentional or not. And BART essentially said, we don't have to, and we're not going to. And the FTA took the $70 million away from them. So there are these isolated suggestions that some departments in this administration are willing to use the power of the purse and to say, listen, the federal money comes with strings attached. You must perform before you receive. And to the extent that that message has gotten out there either through litigation or enforcement actions, or maybe just the anxiety of states and cities and municipalities, I think we're starting to make some progress there, and we're starting to see some of those recipients change their behavior and sort of get right in the first place. So again, isolated incidents, I'd like to find ways to weave these little threads together so that we're at a place where, you know, the tens of billions of dollars a year that go out into the communities, particularly around issues of segregation in employment, in residential settings, in education, in access to transportation, in environmental concerns, that money really is used to undo segregation, just as that money was used to reinforce it for all these years.
Any other thoughts on that topic?
Well, in the area of anti-discrimination law, it occurs to me that there is a driver which is going to change this more than, periodic changes in the law. And that is, American demographers are telling us that within a relatively short period of time, we will be a nation that has no majority race, for sure, or majority ethnicity. And even though, last week's election presented a lot of facets of what I think Judge Nixon would call certainly a part of American history, which is these occasional bursts of nativism where we bash people who choose to come to this country because they find it a better opportunity than the one they left. The demography of our country, I think, will make a change, and white people who are afraid of anti-discrimination laws or find them or disregard them because they don't feel they need that protection, give it a few turns of the wheel, they will. And so I think that is something that is driving and will drive anti-discrimination law and policy in our country. I throw that out. I assert that.
Brian?
Let me respond to what Jeff said. I think that, on the one hand, I think that in the long run, that it'll be healthy for our democracy that there not be a majority ethnic group that can claim that the country is theirs, that it's founded on their principles. It'll have to change over time. But by the same token, even though I'm generally an optimist in approach to life, I am very concerned that we are going through a phase that could be analogized to the white reaction to the initial Reconstruction governments, that kind of setting. I think that from a political science evaluation, we can see that that the fact of the president's election and the fact of some new legislation finally getting passed that had a more progressive bent to it has energized and mobilized a political force. It's not unified, and I don't mean to overstate it, but I think it has energized that set of people, particularly among white men, who are apprehensive about losing that very majority status and losing the capacity to be free, white, and male, so to speak, and have the country be theirs.
It's a power thing.
It is, and I think that over time, while I am optimistic that over time our structure of government can kind of, through a lot of give and take, overcome that reactionary, if you will, response to the civil rights advances. I think that we still don't yet know the extent to which this movement will progress, and can't quite, in my mind, I know I can't yet have a sense of how to gauge how effective it will be over time and how difficult it will be for us in another 5 or 10 years before the forces of social response to that would be progressive can succeed.
I am no economist, but from everything I read, and I'll confess now, mostly in the New York Times, it appears that there is a dramatically accelerating trend of concentration of vast wealth at the very, very top of our economic structure, the top 1% of earners and income holders in this country, and a growing, rapidly growing disparity, economic inequality, comparable to perhaps what was seen in the Gilded Age. And in an era where that kind of economic inequality not only appears to be present but accelerating, what are the possibilities for remedying discrimination? Do you have any thoughts along those lines?
This is obviously not the economist panel.
Right, I didn't see that in my, right. So
Well, maybe now it's time.
In terms of class discrimination in that sense? I mean, I think that
Well,
within
my thought
Yeah.
is that, we live in an era where the powerful and the wealthy appear to be becoming more and more and more powerful and wealthy very rapidly. And of course, as Jeff said, a lot of the issues that come up in discrimination cases are really issues of power and wealth. And in an era where the rich are getting richer, what does that bode for the ability to make progress in areas relating to civil rights and discrimination?
The one response I would have to that is to suggest that while we don't have the answer to that problem, nevertheless, to me it's critical that we continue to fight to have the access to courts and access to justice in the legal system that we've been talking about through the day. The courts are going to play a role. The question is what kind of role in that back and forth, in that inequality. And the only way it's going to play a role that is progressive will be for attorneys to be doing the kind of work you're doing, the kind of work that Jeff's doing, and plaintiffs as well, the kind of work that you did to go through that Texaco case.
Okay, I think we will open it up to some questions from the audience. I know at least one of our panelists will need to leave shortly, but now is your time to ask questions. Yes, sir.
I just wanted to say thank you all. It was hard for me as a non-lawyer to sit through the first 3 sessions of this, and I confess to my friend Lindsay, I'm not sure whether I should be here or not. But I'm really glad that I stayed, and I just want to thank you for all 4 of you, especially Barry Ellen, for your courage. And I've come away from this. I teach robotics inner city to try to working on a new kind of theme of economic development and dropout prevention. And some of these designs are for barrier-free type designs, and they're actually, a few of these designs are actually not legal because they're too small. And so there's a lot of legal issues that come up around this new type of design that we're teaching children to do. And so I just wanted to say that as a comment, and thank you very much. I've come away with a new respect for the law, for Emory Law School, and you know, I'm going to spread that news. Well, I just want to tell you that the association, the American Society for News Editors, I hope that you all get a chance to watch a YouTube about Eric Schmidt, who's the CEO of Google, trying to figure out ways to give money back to the news editors. These are people that are committed, the editors I see are as committed as you are in the leadership of getting the truth out and transforming culture. And it's a 40-minute video. I think it's ASNE. And he's very committed. All of a sudden, he's ended up with billions of dollars. And I think he's cognizant of the fact that he's pretty much ruined the newspaper industry. So I just invite you all to keep an eye out for that.
Thank you. Yes.
Could I just add something onto that quickly? Some of the folks who were behind the Westchester litigation have used some of those proceeds to develop a new nascent news service called Reframing Debate. And I guess sort of in the spirit of ProPublica, the idea is that, you know, we're inundated with all sorts of stuff through technology and transparency laws. There's so much of it we can't understand it, and we need some folks to help us really understand what the frame is. And this is a conscious effort, I think, to undo the sort of corporate statist approach to the way most news is now reported through the mainstream media, and to really get at that issue of reframing.
Well, work with kids. They'll teach you how to use it.
Yes.
Mm-hmm.
I would say that there are two large clusters of reasons that a firm may not take such a case. One is that it is politically unpopular, and if you take a case like that, nobody in town will do business with you again. I'm from Washington, D.C., with a national practice, so we live by doing claims like this. In some ways, maybe we've been successful because it is so hard to find a lawyer in your local community who doesn't want to get crosswise with the political or economic powers in that community. So, you know, we're happy to look at stuff. We have a small core of people who can look at and investigate cases and work in partnership with potential plaintiffs to develop a case to the point that we know whether it's a go or a no-go. I don't know that every firm has that kind of nimbleness that we do, but I'd be happy to talk to you privately. I would say there are a number of firms of this model that are around the country. There isn't one in every community, but I can connect you with folks who might be interested.
I'd offer this other piece of encouragement. Traditional lawyering has always been about a lawyer and one client. And a lot of those cases are not terribly lucrative or huge individual cases. But there's a nobility, it seems to me, that reflects on our profession when lawyers do that work and do it well. And I hope that inspires you at some level.
Yes.
Hi, it was nice to hear all of you speak. Thank you very much for coming and sharing your work. My question is primarily for Michael Allen. You've talked about briefly and alluded to a lot the Westchester case and the False Claims Act. And I'm wondering, because that sort of a claim is, and the way that you use it in the Westchester case, because that sort of a claim or involves an element of secrecy, right? Like you can't really talk about it because that's one of the elements of the claim. When you're dealing with a large community issue such as segregated housing that is prevalent and oppressive, how do you find that as an attorney, the effect of such litigation on a large community such as a metropolitan area? And do you think that there would be tremendous or even considerable backlash to the kinds of remedies that you might be able to work out, even such things as inclusionary zoning or that sort of thing, whether a community that hadn't had sort of a groundswell around the case because of the secrecy element would then react badly to the outcome of the case when the idea of the case to begin with was to remedy the situation?
Do I have about 6 hours to answer the question? Somebody said earlier that's a seminar all unto itself. I guess on the first point, I look to Reuben Gutman, who's my False Claims Act mentor. The issue of secrecy is at a particular part of the case early on. You're bringing a case in the name of the United States as an individual or an organization, and you've got to give the government a chance to either get in or decide not to get in. And then the matter gets unsealed and it's litigated like any case. So then it gets to be as big or small as it deserves in terms of newsworthiness. There's certainly ways to work with community groups as relators in false claims cases in a way that you can maintain the cone of silence during the appropriate period, but also have them ready to launch when the time is appropriate. And on the remedy piece, I guess what I'd say is, just look at what's happening in Westchester now. I mean, Westchester faced $150 million of financial liability. The case was settled for far less than that, with the government coming in and requiring the county to put 750 units of affordable housing in the whitest neighborhoods of Westchester and affirmatively market them to people of color. So there's an integrative purpose behind all of this. But a year into the settlement period, Westchester's digging in its heels. Its new county executive has vetoed an important piece of legislation. The monitor isn't being as vigorous as the Anti-Discrimination Center would like. People are going back to the way that they used to do business, which is we don't have to do this. So at some point, in this case, there's at least a framework to be back in front of a very smart federal judge who can ensure that the provisions of the federal court order are complied with. We have a path to doing that, but it doesn't make it easy. This is going to be for the long haul.
Michael, if I may, first of all, I am absolutely blown away by your question because you hit this a critical problem with the False Claims Act. Many times you bring these cases under seal and they raise matters of public policy, and you see it typically in the pharmaceutical cases where somebody's saying that a drug causes injury to the public, and yet the case remains under seal for 9 or 10 years. But I say that you should read, this issue is being briefed and argued, or was argued in the Fourth Circuit, with the ACLU challenged the constitutionality of the seal. We can get you the site. That case is pending. So this is really, and the National Law Journal I think has done some pieces on this. But Michael he is my idol in terms of these. He's wonderful, and I commend you to read actually the settlement agreement in the Westchester case, because that agreement, unlike any other false claim settlement agreement that I've ever seen, okay, requires an independent monitor. So what the community is left with, this is incredible, I hope it's working, transparency. And I can tell you the Justice Department doesn't like it because they consider these independent monitors a pain in the neck. But Michael is one of these people who not only got an incredible settlement monetarily, but left the community with a mechanism to enforce compliance with the court's order.
Thank you.
Did you have a question?
So, two things. I will echo what the first questioner said about his admiration for the panel, and particularly his admiration for Sister Roberts. With plaintiffs like that, it's easy to litigate lawsuits. Easier. And I appreciate Dean Brokaw raising the economic point. I would recommend to people on this a book by Robert Reich called Aftershock. You're absolutely right. At this point in our country, the top 1% of people have 25% of the wealth in the country. We haven't seen that since just before the stock market crash and the beginning of the Great Depression. And the big problem is that I think the fact that the middle class and workers generally haven't for the last 30 years gotten their fair share of production makes it extremely difficult to remedy a lot of these problems, because it's a decreasing portion of the pie that's available to people because of that. If workers had kept up with production over the last 35 years, they'd have 60% more in average annual income than they have right now. And I think that casts a tremendous pall over everything. So it's not a question, it's a comment, and I appreciate Dean Brokaw for you raising that.
Yes.
I had a question for Barry Ellen. When you talked about the lawsuit having been brought, and at some point Texaco appointed a diversity board, and they were all white males, I was shocked and thought that was a pretty angry response from them, and I wonder how it hit you.
Well, it's not as though they had a lot of other people to choose from. That's why I brought the suit. I mean, it's like the time, I think I was in my deposition, and the attorney said to me, show me in our policy, show me in the Texaco policy where they say they discriminate. I was like, show me in the Texaco company somebody else that looks like me, okay? Show me some other African-American women. Show me some other Asians. Show me anybody else. Show me some measurables that say and that show that you don't discriminate. Okay, so when they put together, like I said, when they put together the diversity panel, since I was suing them and I was the only person there in corporate, there was an African American woman other than a few secretaries who obviously were going to say no. They were not going to go in the room and speak. Okay, so that they didn't have anybody else, but they wanted to show on paper that they had a panel. So it was never their intent to have anything but it on paper, so that, the next time we went before the judge or the attorneys went before the judge, they could say, well, we have a diversity panel. And that's how they played the game all the time. When I got there and I said to them, I said, okay, so, where are the other African Americans? And they're like, you're it. And I was like, what do you mean I'm it? Because prior to me coming there had been absolutely no African Americans. At the grade level that I was at, there had been maybe a few white women, a year or so before. But prior to my suit, a group of white women had tried to sue Texaco, and they had decimated them. You know, they had just gotten rid of them, and that was their practice. You know, scorched earth policy. We're not changing, but we're going to burn anybody that speaks up. I did not know that coming in, but shortly, maybe a year or so after I was there, I didn't know that coming in. Actually, quick story, how I got there was that Texaco had gone through this huge Pennzoil suit, and they had lost. And as going through that suit where they had lost $3 billion, when the government came in to look at everything, they noticed, you know, when they looked at their human resources, that said, hey, you know, you need to be inclusive. You're in the New York metropolitan area. It's not as though you'd have to go somewhere else and recruit. You're here, you have a pool of people, but you don't have anybody here. Any women, any African Americans of color, other than some secretaries and people who've been here for 30 years and never been promoted, never even been considered. So when the EEOC saw that, they challenged Texaco, and that's when Texaco recruited me, and I, in a sense, became their affirmative action program. I was a woman, I was black, I was 40. They were whole, they thought.
I just want to say something as Barry Allen's lawyer during that epic case. What Pat said about how much easier it is to have a high caliber plaintiff is an understatement for Barry Allen. I mean, she, being in the room with her when she was deposed for 2 days, when they threw everything at her, and seeing how unflappable she was and how strong she was, that to me was an inspiration then, it's an inspiration now. And it's just, you know, you're just a remarkable person, Barry Allen, to go through that. And it's really terrific that you're here.
Thank you.
Any other questions, comments? Well, it is almost 3:30. I'm going to give a huge thank you to our wonderful panel here, and a thank you to all of you for staying on a Friday afternoon. And thank you very much. I think we'll adjourn.